Welcome to Laws 11057, Introduction to Law. This is week number 2 in Term 2, 2014. And tonight our discussions will be based around the new lawyer, chapters 3 and 4. And that's the textbook, which I'm sure you're all very familiar with now. An excellent text, a terrific read. So I'm going to base my comments loosely on the material and supplement that with my own comments. I encourage everyone to ask questions and contribute material as we progress, so don't be shy. Firstly, dealing with Indigenous Australians and the law, pages 85 through to 91 in James and Field. So, of course, we are referring to Aboriginal people and Torres Strait Islander people of Australia, and it's very good that it's the NAIDOC week this week. Some more significant Aboriginal communities include the Murri people of Queensland. Unfortunately, the Murri Court, which was, to my mind, a fabulous innovation, has recently been disbanded. It was disbanded as a result of monetary and other reasons, but it was a specialist court that dealt with Aboriginal disputes and provided for members of the Aboriginal communities to assist in that process. Aboriginal customary law comprises of elements of law, spirituality, ceremony and business, and these days we talk about the advent or the history of Australian law commencing with Aboriginal and Indigenous customary law, and that's only a relatively new innovation. And I say it's an innovation because up until the decision in Mabo, there was no recognition in relation to Aboriginal customary law at all. And of course, I'm referring to the principle of terra nullius. And you'll recall from your readings that at settlement, that is after European settlement, Australia inherited the common law and legislation of the United Kingdom. And that was possible because the settlers declared that Australia was terra nullius, that is unoccupied land. And British declared Australia to be empty land, therefore there was no treaty. The Indigenous Australians were seen as not having a legal system in place, and therefore there was no sovereignty to relinquish to the British. In other words, it was deemed to be settled rather than conquered by the British. So that Indigenous legal system, which was very long-standing and sophisticated, was completely ignored and remained ignored until 1992. In 1992, we had the very important High Court decision of Mabo against Queensland number 2, 1992 175 CLR 1, and the High Court considered the claim by Eddie Mabo and others on behalf of the Meriam people. Now, there is almost certainly going to be something in the exam in relation to Mabo and the role that it played in the development of Australian law. So there's another exam tip. Last week's tip was separation of powers. Now, I'm just muting some microphones, thank you. But please feel free to jump in if you wish to make any comments. So the need for the Mabo decision came about as a result of uncertainty following the introduction of the Queensland Coast Islands Declaratory Act in 1985, and that in itself was passed as a result of the Queensland government seeking to resolve any uncertainty in relation to islands in the in that region, in the Murray Islands in the Torres Strait. So the Act sought to abolish any claim to ownership of the islands by the Murray Islanders. Mabo and others commenced that legal action, challenging it on the basis that it contravened the requirements or the terms of the Racial Discrimination Act of 1975, and therefore was invalid under Section 109 of the Constitution. A couple of things there. I recall I commenced my legal studies in 1977, and in year one I did my paper on Racial Discrimination Act, so it was of great interest back then, not only to me but to many people. It was a great time for legal innovation in the 70s, a really good time to start studying Family Law Act and a few other things, major developments. Anyway, Mabo brought that claim, and it was held by the High Court that the Queensland legislation was invalid because it was inconsistent with the Constitution, inconsistent with federal law, and Section 109 of the Constitution provides that if there is a conflict between federal and state law, then not surprisingly, the federal law will take effect and precedence over the state law. So the Islanders were successful in that case, and the second legal action, which is why we call it number 2, was brought by Mabo before the High Court in order to have the rights of the Meriam people formally declared, and that was done. So the previous view that Australia was terra nullius at the time of settlement was declared by the High Court to be wrong and forever regarded as wrong, and as a result, because of the continuous and ongoing connection and occupation that the Meriam people had to the Murray Islands, that then was deemed to survive British settlement. So others in a similar situation were in a position where they could bring traditional title claims and could not be taken away by express laws. As a result of that decision in the High Court in 1992, the federal government passed the Native Title Act 1993, and that legislation established a scheme for determining the existence of native title and validating past Commonwealth action in making land grants inconsistent with the property rights of Indigenous Australians. The decision of Wik peoples against the state of Queensland sparked considerable controversy when the court decided that a grant of pastoral lease did not necessarily extinguish that native title. All right, so there's I mentioned before that I did environmental law, so you can imagine that that has a great bearing on environmental law as well. So ultimately we can conclude, and at page 91, James and Field state that the present legal position is therefore that Australia was not terra nullius at the time of British settlement. Any questions, any comments? I see there's a few comments on chat, mostly people saying hello. Does anyone wish to make any comment about native title, Mabo, the reasons for it, terra nullius?
John?
Yes.
Hi,
Rhys.
sorry, Rhys. How are you doing? Good.
Good. Welcome aboard.
I just want to thank you very much. My background is obviously from South Africa, so in that sense, land claims is a major issue. So I just wanted to know how far back or what the practical implications of all of this would be, because obviously if you have, for instance, a city settled in a previous native settlement, what do you do? Is there a claim for compensation, or what do you do?
Look, you can, but it is notoriously difficult to establish a continuing native title claim, particularly exclusive title, and it needs to be a continuous and exclusive title. But essentially the matter is dealt with now administratively through the provisions of the Native Title Act. But it's certainly not easy to do, in short.
Okay. So in theory and in practice, two different things.
Well, yes, it's certainly groundbreaking legislation, but we're not seeing, I think it's fair to say, a lot of significant native title claims being made. I guess they're significant to the people making the claim, but mostly they're done through that administrative scheme, which was established in '93.
Native Title Act, yep.
Okay. Thank you, Rhys.
No.
Any questions or comments?
Yeah, I think Chapter 3 was a pretty big eye-opener to myself, and I understand a few other people as well. It was very good reading.
Okay, yes, thanks. And Tony, I think you wanted to make a comment. Thank you, Jason.
Yeah, native title, it's extinguished on freehold property, isn't it? Freehold land.
Yep, that's right. Okay, all right, thank you. Any other questions? Let's move on. The development of British law. So we've dealt with Aboriginal customary law, British law, some interesting history. The Magna Carta in 1215, King John executing that to acknowledge a range of fundamental rights held by English citizens. I gather forced upon him more as a result of economic and military reasons rather than wanting to be altruistic in motive. But nevertheless, the Magna Carta was the first real acknowledgement of a range of fundamental rights held by citizens. Later, King Edward I met with the Great Councils, and that was referred to in the Parliamentum. Sorry, I don't know why that was so hard to get out. I'm a bit distracted because whenever I read of King Edward I, I think of Braveheart. That was that era. Now, common law and equity. At common law, the rules were very strict and strictly adhered to, and we talked about this to some degree last week. Equity provided more flexible and wider range of remedies. That's referred to on page 96 of the text, James and Field. And English citizens could seek an appropriate remedy based on common law, or they could go to the monarch and seek royal justice directly. Now, the Lord Chancellor took up on behalf of the monarchy and established his own court in making decisions based on equity and good conscience. That is by the 1300s, and that's on page 97 of the text. So the Lord Chancellor began then to have regard to its own decisions, and the doctrine of precedent was born. And those principles mean that decided cases would be relevant in the way in which future decided cases would be considered. And for centuries then, we had these two separate court systems operating side by side in England. In 1873, which is really not very long ago, the Judicature Act, which is an imperial act, of course, allowed the High Court of Justice to administer both common law and equity. And even today, as James and Field quite rightly point out, law and equity continue to exist as separate branches of case law, albeit that many courts can provide remedies either at law or in equity. I know that's a very confusing concept when you're coming into the law, how you can have these different streams, but it's historical, and while there's been a substantial merging, it's not complete. For example, many of the courts simply don't have an equitable jurisdiction. So Magistrates' Court, for example, don't have an equitable jurisdiction in terms of remedy. A very common example of an equitable remedy is specific performance, which is an order of a court effectively compelling a defaulting party to proceed with the transaction as agreed. Mostly we see it in the context of real estate. So you can't go to a magistrate's court and ask for an order of specific performance. That court doesn't have jurisdiction to grant that equitable remedy. You need to go to a different court. Now, through pages 91 to 98, James and Field make comment in relation to Indigenous Australians and the law today, referring to the Statute of Westminster, providing that the British Parliament could no longer legislate for Commonwealth of Australia without its request and consent. And again, that seems extraordinarily recent. And it was only in 1986, through the Australia Acts of both the Commonwealth Government and the UK, when they came into force, which effectively severed the legislative ties between Britain and Australia. So all very recent. Right, so any questions then about common law, equity, and the role that the UK Parliament has had until recently in Australian law? Any comments, questions?
Hi, it's Libby. How you going?
Yes, Libby. I'm fine, thanks.
That's good. I'm sure there is a reason that equity isn't a part of every court, but I haven't been able to find that reason.
I'm not sure there's any particularly good reason, but I guess different courts have different focus. And to take a sort of silly example, you wouldn't go to the family court if you were seeking to enforce a contract in relation to the sale of land. So that court has its own rules, its own regulation, its own area of practice, if you like. And in the magistrates' court, it has primarily a criminal law focus as sort of day-to-day work, and it has a focus in relation to monetary claims up to a certain amount, but certain types of monetary claims. So I guess rather than burdening every court, every magistrate, every judge with the full range of legal work, there's a degree of specialisation. And I guess that degree of specialisation means that resources are more rationally used as an economy of scale. I hope that makes sense. Thanks, Libby.
It does.
All right. Any further questions? Okay. All right. Well, I think that covers that. I'd just like to make some comments now in relation to Chapter 4. I'll leave you to read the rest of Chapter 3 for yourselves. And it's the Australian legal system. We've talked about that to some degree already. And it's an interesting topic in that it deals with, amongst other things, the basis upon which our democracy works, that is a liberal democracy. The rule of law deals with the separation of powers. Now, I think we've covered that last week. I'll cover it again briefly. So our government is made up of three branches. That is the legislature, which deals with the making of laws, Parliament, essentially. The executive, which is the administrative branch, which administers the laws and is responsible and reportable to the Parliament. And the judiciary, which interprets the laws. In general terms, it's fair to say that the closest link is between the Parliament, the legislature, and the executive. And indeed, some parliamentarians, such as the ministers, are also members of the executive. So there's a clear crossover there. Then there's not an entire separation. But standing well to the side is the judiciary, which is meant to be very independent. And of course, we've seen lately in Queensland, at least, instances where the judiciary wants to assert its independence on an ongoing basis as having the ability to interpret the law. We've seen that recently with the High Court making decisions in relation to international matters, which perhaps doesn't please the federal government, but nevertheless shows clearly the role of the courts in terms of ensuring that citizens and governments comply with the laws and the legal obligations. So, any questions then about the separation of powers? How are you going with your research and your reading on that? Okay.
John, I just have a question.
Yes, Melissa.
With that crossover, how, like I asked on UCRI, how does that comply and adhere to the doctrine of separation of powers when there are people that are members of both?
Sure. And yes, it's a very good question. And I guess the strict answer is it doesn't, which therefore means that we don't have a strict separation of powers in our Westminster system. But it's there in concept, and for the most part, it works in practice as a separation of powers. But there is that clear crossover area, that common area between the Parliament and the executive. I'm not sure I can explain it any other way than that. So it's not a clear separation. It's a bit fuzzy around those edges. Thank you, Melissa. All right, federal and state relations. We do have, of course, the Australian Constitution, which came into effect on the 1st of January 1901. And I'd refer you to a couple of sections in the Constitution. Section 51 sets out the heads of power for the Commonwealth Government, and one example is 31, Roman 31, which is the power to acquire property on just terms. We've all heard that from the castle. And that's an area that really has some significance in environmental law as well. But there are many powers there. Another is, say, 35, which provides for conciliation and arbitration and prevention of industrial disputes, which is a form of alternative dispute resolution. In the commentary, there's reference to the case of Commonwealth against Tasmania, where the Commonwealth Government introduced laws purporting to regulate environmental issues in circumstances where it did not have power conferred upon it to make laws in relation to the environment, which was probably an oversight, but nevertheless, that's what it is. So in some instances, the Commonwealth Government needs to rely on other heads of power in order to enact laws in relation to areas where it does not have the power. So I'd refer you to the Commonwealth against Tasmania High Court decision from 1983 in that regard. Now, some powers are concurrent powers, meaning both the state and the Commonwealth have power to make laws in relation to them. Other powers are residual powers, and at page 128, James and Field identify those residual powers, or the main ones, which are conferred upon the states. So criminal law, contracts and torts, transport, etc. But even then, they're not truly residual powers in that, for example, in criminal law, there is in Queensland a criminal code, as there is in Western Australia, and other states have their own criminal laws, of course. But in addition to that, the Commonwealth does have its own criminal code, the Commonwealth Criminal Code and the Crimes Act, and other pieces of legislation that clearly deal with criminal law, even though that is not something which is specifically referred to in the Constitution under the heads of power. So it's a very grey area at times in terms of what the High Court can and can't do. Now, in the 1980s and the 90s, we had a great number of cases which went before the High Court dealing with essentially constitutional issues, the state versus the Commonwealth primarily, and many of those cases went against the states, which meant that despite the great cost associated with the claims, the states were unsuccessful for the most part. I can give you that example again of Commonwealth against Tasmania. So now there's been a much reduced rate of challenges in that regard, and a much more cooperative approach has been taken collectively by the states and the Commonwealth. An example of that cooperative approach is in terms of the instances of legislation which has been introduced collectively across each one of the states as uniform legislation. So we'll see that from time to time, a reference to uniform legislation, Australian consumer law, for example, where the states work cooperatively with each other and the Commonwealth to ensure that laws are consistent, even though the Commonwealth doesn't have the power necessarily to make that law for themselves. In Chapter 4, the authors go on to talk about the executive powers and the Executive Council. I'll get you to read that for yourself. Some of the jurisdiction where there is power